Hello, everyone, and welcome to Family Law Fridays presented by Florida Women's Law Group. My name is Jadelyn Fleischer, and I am a legal intern here at Florida Women's Law Group. Family Law Fridays is designed to be a resource for all women with any type of family law issue. Before we get started, here at Florida Women's Law Group, we want you to know that as the situation around coronavirus continues to evolve, we will remain open and available for you since we have the ability to operate 100% remotely. As always, the safety and security of our clients, potential new clients, and team members remains our highest priority. We take great pride in maintaining the highest standards of operation, even through this time of uncertainty. We are still requiring all client meetings and consultations to be conducted virtually, and here at the office, we have promoted all staff members to practice social distancing by reducing physical contact with others so we can all continue to work on your case. As always, our phones are open and we are happy to have meetings with you via phone, Zoom, and are still available to communicate through email. So with that, today we'll be discussing how the court's consideration of an emergency has changed throughout COVID and how women are dealing with these changes around the world. Now, I would like to give you some information about our host, Heather Quick. She is the founder and CEO of Florida Women's Law Group, which is a family law firm that advocates for women in North Florida. The firm educates and empowers women on their rights in the law so that they can find the strength to endure the process and end up better financially and emotionally. Heather Quick has been a licensed Florida attorney for the past 20 years, with the majority of her practice being in family law. Please join me in welcoming Heather Quick to Family Law Fridays.
Thank you, JD, so much. And it's wonderful to be here with you today and talk about really how the courts are handling emergencies in this time where we're still dealing with what I would call limited access to the courts, limited relief, a lot of issues that are everyone is facing currently. And in family law, which is of course our specialty and where we focus in our representation of women, there are instances when it involves your life, your children, your finances, that it frankly can, many times everything can feel like an emergency, but it's always urgent and you are looking for relief. And the current status of the court systems are troubling to say the least, and very much so putting a roadblock in front of so many people and stalling cases and really creating, in a lot of ways, more problems for individuals. And so that's what I wanted to talk about today, because with every problem, there is an opportunity. And one, it's important from my perspective to provide you with this information, because if you can act prior to the situation getting to a point where it feels as though it's an emergency or it is actually an emergency, you will be better off. So that's what this is about here today. I want to give you this information. If you feel as though maybe, oh, well, that's not where I am now, but maybe now that you know this information and you can discuss with your lawyer where your case is going, what things are happening, your attorney will be able to pretty much give you that forecast of where things are going if things aren't changed now. So this should hopefully help you. And if you're not currently in a family law situation, but you may be someone that you care about, love, know is experiencing this, please share this and hopefully this information will help them. I am not in charge of any of the court systems. They've not asked me my opinion. So therefore, I'm not telling you I am providing all of the solutions, but I am providing, one, awareness, and two, some creativity within it, and also just bringing it to your attention so that maybe you can sidestep whatever is happening from being an emergency, or just having that awareness and helping you navigate so that you're not so blindsided. Because many times in the family law arena, in litigation, when you feel like you've just been sucker punched again and again and again, it gets old and it gets exhausting. And I am a proponent of, an advocate for knowledge. Knowledge is power. And it doesn't mean that punch won't hurt as much, and you may still take some hits in order to get to the finish line, and they just won't be as painful. And because when things happen that we just don't expect, it's harder to cope and prepare. So thank you for being here today, so we can talk about that. So now we've experienced it, and we've talked a little bit in some of the prior Family Law Fridays, the impact of COVID-19, the shutdowns of the court system, what was happening, what was not happening, and how that may, pertain to your current divorce case, your past divorce, but how that would affect it, time sharing arrangements, and of course the health and safety of you and your family. So I wanted to focus today, though, on an emergency or urgent matter. Now, what brought this to my attention, I do read a lot, and of course, not always legal articles, but a lot of times just, what's going on in the news with individuals, particularly if it relates to divorce. So now we all know that New York is pretty much a hotbed, so densely populated, a lot of issues very different from, say, here in Florida, that they are facing with these stay-at-home orders and just the complete change in lifestyle. Well, those court systems had previously been, I'm not going to say shut down because I don't have personal knowledge, but of course, we're not taking as many civil lawsuits, filings that weren't probably dealing with criminal matters and due process concerns. But anyway, I saw an article in the news this week regarding Mary Kate Olsen, Olsen twins, and she had filed for divorce from her husband. She lives in New York in April, but many of the filings were delayed. Certainly there were no hearings to be had. And apparently the situation, as reported, was that the husband isn't renewing the lease in their apartment where they are currently residing and, abiding by these stay-at-home orders, and told her she needed to get out of their apartment by middle of May, and he hadn't renewed the lease, and she really didn't have, and said that she believed that was an emergency. The courts didn't see it that way. And that's part of what I did want to discuss, is how the courts have in the past defined certain things, how they are now. But in New York, the court said that didn't qualify as an essential matter, and therefore they weren't going to make a ruling. Sometimes they can just make a ruling even without having a hearing, or schedule a hearing in a very short amount of time so that someone can get relief. And that just brings up a really important issue, because let's say you are leasing property and you're only one spouse is on the lease. That happens. That's not uncommon. And they don't renew it or whatever, and that deadline's coming up, and you may or may not have the funds with which to move, the desire to move, particularly in light of what's going on, and you are seeking relief from the court, because at that point, you can't certainly force your spouse to renew the lease. You may try to persuade them, but they may choose not to. What's going on with the landlords? Can you just stay? You don't want to really get in that type of civil situation where there's a dispute over whether or not you can stay. And of course, the financial impact. But there's also a health and safety consideration, because particularly if you are within that at-risk population as identified by the government, and you really don't have a place to go, but where you are, it's clean, and very few people have been there. I think that is a new concern that we didn't have 3 months ago. It wouldn't have been something, as a lawyer, I would have been able to make a case for that. Well, the current living situation is sanitized and has been contained, and we know there has not been any contamination from anyone else there. That was just not even an issue that used to come up, but now it is. So those are all things that as we know, and I personally say, yeah, that would definitely feel like an emergency, like a situation that I need relief from. If my husband and I cannot come to an agreement, he's just going one way, but I need to alter that course. That's where we seek relief, is going to court. And right now, the courts are only allowing matters that are emergent in nature or essential. So let's look at what that is. I can only speak to our Florida court system, but I would believe and I would assume that they're going to be similar, and they're going to be nuances within each, of course, area that you're letting courts you're practicing in front of. So normally, in the normal practice, or in the old normal, because this will be now the new normal, but prior to the COVID-19, have a client come to me and say, I need this emergency motion filed right now. This is, I've got to have relief from this. And then we discuss it. We discuss, well, tell me what the emergency is, so that I can assess if it's going to meet the court's criteria. Because many times when they are considering an emergency and looking at that, they are looking at, is there a risk of harm? That's going to be the number one thing that the courts, the judges are looking for when they see the word emergency. They're looking for the threat of harm or immediate danger. Now that we can, discuss, like what could the danger be, now that we're looking at health risks and things like that, that can be different. And I'm not saying that it wouldn't meet that criteria. But it's almost, did you call the police? Did you call DCF? Did you call a resource that you would call in a defined emergency? So that's the type of mindset and approach the court. That's where they're thinking when they're looking at that. And that's fair, because within everyone, I will raise my hand as the biggest offender. If it's happening to me, it's an emergency. And not that I use that word lightly at all, but when it's something that I want done or that is bothering me, affecting my life, I want it done yesterday. So I understand in that everyone feels that way. Maybe everyone doesn't, but I understand if you do. But when we look at it from the courts, who are getting so many things in front of them, and they have to essentially triage, which is what happens in the emergency room. And it's really 1, 2, 3. And hey, you stop breathing, heart stop beating, boom, front of the line. You have a headache. Now that I don't want to go too far in, because that could be something else, but maybe you just have a sprained ankle. That's what we'll do. That's going to be a 3 as compared to the 1. If there's nobody else in there, then the sprained ankle gets bumped up. So that's really just, if you can understand, that is the approach. And they are daily receiving many filings with situations that go from a 1 to 10 in severity. So they're looking for that threat of harm, that immediate danger, an immediate danger to your health, wellness, safety. And unfortunately, because I may disagree, but in family law, there are always financial issues because, frankly, my point of view is the person with the money, controls the person, particularly in a divorce case. So it's a common theme that the person who has control of the money, they take on a tighter control of the money during the divorce in order to control that person and control their spouse. So there may be limited funds available. And generally, our best relief for that is to go to the judge, but they don't consider that an emergency, that, he hasn't paid support. And because, like I said, they're comparing it to the health and safety and people who are in physical danger. So it can be, when we're talking about this, I really want to, these are a lot of general statements, because that could be one factor, but then the money pays the electric bill, it's reaching 100 degrees, your child, may need not a respirator, but the breathing machines, having to do that for breathing treatments, needing electricity and the heat, and it affects their health. Okay, so then now we tie all that in together. That moves up in the level of emergency. So I'm not saying excluding all of that. That's why it's so important to clearly communicate all of the facts to your attorney, because it's very fact specific. And that's what we do. We draw out the facts, apply the law to allow the court to see what is going on and what that risk may be. So we have financial, that there are times when it does rise to that level, but there's got to be more than the check didn't get deposited. There have to be the effects of that and an overall understanding. So again, it's there, but it's not as as high up on the chain. Now, violence, yes, and we had a Family Law Friday, I believe earlier in the month, as it relates to domestic violence, situations of domestic violence, and that the courts do address that specifically through injunction hearings and orders of protection, because that's very serious, needs to be communicated clearly as to the threat and the facts that occurred. The courts do handle that on an emergent basis, and they do a good job with that. That is something that the statutes provide. The law has been created so to address that and minimize the deaths as best they can, to at least allow some way that you can seek protection for yourself in that situation. And likewise with children. So when we are looking at an emergency issue, we really need to look at what is going on with the children. If you have children, that is going to take a higher up on the chain, because children are relying on their parents to protect them, keep them safe and healthy. So therefore, if there's something affecting that child, they can't fend for themselves. We're adults and parents are adults, and they should be able to figure out a way to take care of themselves. And, and I'm just saying, I think that's the court's perspective. And I don't say that I disagree. As adults, we are in a much better situation than children. So therefore, if any of these issues are affecting the children, that is going to be, again, bumped up. And that's where, within the environment we're in now, when we're talking about the COVID-19, the stay at home, and now here in Florida, as of today's date, we are seeing much more less stringent guidelines, and everybody getting out of the house, getting back to work. I believe camps are going to be reopening in some fashion soon. So we're going to be getting back to normal to some extent. But again, many individuals, many parents have children who may be at risk, maybe because of respiratory or their immune system may be compromised. So that in and of itself creates a unique situation that we didn't have before, but it does fall under their health, wellness, and safety. So those are issues that, again, depending on all the facts that support them, there's usually not one particular thing. It's everything that comes together to present the situation. I mean, it is the situation, but how you present that situation to the court that gets you in front of a judge sooner, because that's really what we're talking about here. We're talking about, you're in a situation, you're unable to resolve it yourself. Now, I think that many of the lawyers have been more creative and definitely more proactive in helping their clients, but there is also the situation where you have the individuals who see that as their advantage. And unfortunately, so does their attorney, and they are not going to cooperate. They're not going to work things out, even while we are in a situation with limited access to the courts in some areas, and not all areas. I will be frank, it varies based on the county and circuit that you live in as to the access of the courts and, frankly, the availability. that the courts are making for the public. Not all courts are making their services available. So therefore, the individuals who reside in those counties are the ones who suffer from that. And there is, at this point, more opening as of next week. And that'll just have to be seen. And we'll continue to monitor it and let you know. But when we are looking at issues as it relates to children, particularly their health and safety and wellness, that is going to be considered definitely more on closer to an emergency than if it's just an adult. And just like I said, based on their inability to care for themselves and really their vulnerability. And when we look at that, we just have to assess what are all of the facts that support your situation, that if in front of it, if a judge sees them, they may say, hey, one, either I can issue an order without having a hearing. That doesn't happen very often. Or I'll have a hearing within the next few days so that I can hear what's going on, make a decision to create less of an emergent situation and maybe prevent that. Now, if you are in a situation that you're thinking about getting divorced, and that and maybe, you know, that was something you thought about prior to everything, you know, a lot of this shutdown that went on with COVID-19, and now after all of that, you're more than certain this is the way you want to go. I want to talk about a few things so that you can do now to prevent yourself from a situation where you're feeling as though this is emergent, this is something I need to have handled right away, and you're running up against the wall with the court. Because the facts that the courts have been, you know, slowed down for a period of time, everything that was scheduled is getting back rebooked. So some counties did better than others and really made accommodation and kept things moving. Unfortunately, some didn't. So the ones that didn't are going to have a backlog. Even the ones that kept things moving, there were still a week or so of delay. And when it's a 5-day, 40-hour week, essentially, of cases for 2 weeks, that just creates a lot of backlog that we're all going to see for a while in scheduling. And that's part of the reasons why it takes so long many times when you're trying to get in front of the court. So let's talk about getting ready to file for divorce. So you heard me discuss as far as the range and how they triage what's an emergency, what they're going to list, here first. Okay, finances. That isn't going to get you to the front of the line. So if you know you are preparing to file for divorce, you think about, what is it that I need financially? How can I secure that? What can I do now before filing to protect myself? Because you need to be prepared to have, normally I would have said 60 days. I'm going to say 90, to know that you can make it for 90 days. And I say that as out of an abundance of caution so that you can make it financially. Now, if other stuff comes up that fall into those, higher ranked emergencies, that's different. We handle that. But financially, understanding where that is. If your lease is up at the end of July, that is not something, I'm not sure, depending on what jurisdiction we're filing in. Next week's June 1st. I don't know if you filed today that I could get that heard before a judge to extend the lease. So think about that now. Think about, have you filed? Have you two talked about it? Maybe you should look at renewing before filing. At least it gives you more time. At least finding out with the landlord, can you do month to month? what are your options? What are your options with your family for help? So think about those things, because that right now is something we can foresee, and that we can maybe do some things now that make it less of an emergent situation a month from now. Same with knowing what the bills are, what decisions need to be made, what money needs to be had. Do you know where your children are going to school in the fall? And I know we just ended school right now, and it was very anticlimactic. However, I think we're all hopeful. Speaking as a mother of three, I'm very hopeful school will resume in August. But do you know where they're going to go to school? Is that something that needs to be decided between you and your spouse? And is it something that's a disagreement? And that goes for anybody, even if you're already divorced, if you are separated in the middle of the divorce, try to think more future related. Think out 3 to 6 months. What is going on that you know now? Because enough's going to happen that's unexpected. So think about right now, what do I need to plan for? What am I going to need decisions on? Because what can we do now that puts everybody on notice? We need that. We need those decisions. And or at least you've shown to the court you've made an effort to communicate with your ex or your current spouse, and he's just not going to be reasonable or agreeable. That works in your favor as well, particularly if that's evidenced in text or emails, because you've tried to resolve it and tried to come up with a situation, or try to come up with a scenario, a compromise, something to no avail. So those are some of the things that are at least foreseeable. I'm not saying they're preventable, but they're foreseeable, and knowing where you are now and what lies ahead in the future. If you haven't filed yet, think of those things and go talk to an attorney, because there may be ways that we can help right now. You're wanting to move before school starts to another area, really need to work on it immediately. You need to be calling an attorney right now, because that's going to be problematic. And the law provides you're entitled to a hearing within 60 days. So if that's a situation and it does impact children because you're moving them, that's something that you need to get on right away, so that we can help you determine what evidence you need in order to proceed forward on that case. And, the one thing I didn't touch on, although it falls into the health and safety, wellness, and violence within emergencies, but it is substance abuse. That has been I think we will see the effects of the increased, alcohol, tobacco use, drugs, illicit drugs during this time. If that's an issue, that is generally handled as an emergency. If, it's putting you or your children in a dangerous situation. If there are no children involved, there may be other things that, put you in an unsafe condition with substance abuse of your spouse. So that's something that we can't handle, as well as mental health issues, which again, we did do a Family Law Friday specifically dealing with mental health and Baker Act, and really Marchman Act, a lot of resources not everyone is aware of, and that are still completely open and available, that may be the better first thing rather than divorce, because you can actually get relief. So those two things that are very, very common, exacerbated by this situation that we've all come out of, and in the change in just everybody's everyday life, that we can still get some relief from the court, but it's very important that we are taking action immediately, because one, the things you do now will help either get us to court sooner or alleviate this situation, but being prepared, knowing that it could take several weeks to get just in front of the court. And again, that does depend on what area, what county you're in, and of course the facts of the case. And some judges have more of an open calendar than others, and they will get these matters heard. And what we do sometimes is we don't, it's not an emergency, but we would like an expedited hearing, So basically we're saying, okay, we understand the definition of emergency. It's not that, but we really want an expedited hearing because we want this heard, like yesterday, which is like I told you, everybody else. But many times the facts support that. And the judge ultimately gets to make that decision as far as what's going to be heard and when. So I greatly appreciate you tuning in today, and I hope this was helpful. The goal now is, and it has always been with all of our clients and women out there, is to educate you, get you information to, one, empower you with the knowledge and to help others so that you know what to do. And essentially, if you are in this type of situation where you're about to file for divorce or you're in a divorce and you're really feeling as though your issues aren't being heard because the courts aren't setting hearings or aren't addressing it within a timely fashion, talk to your attorney, reach out to us, get some feedback and advice on maybe there are ways to get you that relief, because it's a frustrating, can be stressful time, and it's already a stressful situation enough when you're going through a divorce or you're in a dysfunctional and unhappy relationship. Then you go into the legal arena. It's stressful. It just creates sometimes some chaos in your life. And then we add this pandemic and just some changes in uncertainty as it relates to how we are all going to operate in this world, and our children, our jobs, and our travel, everything that's going to relate to that. So please know we do understand, we recognize that, and our goal here is to do everything we can to empower you with the knowledge. We may not be able to fix everything, but we can definitely provide you with those options that are available to you and the knowledge of how to best change your situation. So again, I thank you for watching today, and JD will give you all the information to reach out to us, and we look forward to helping you and getting you through to the other side. Thank you so much.
Thank you, Heather, and everyone who's able to listen in today for Family Law Fridays. As always, if there's a topic you would like addressed or a question you would like answered, please call, email, or send us a Facebook message, and it could be addressed in an upcoming video. Additionally, like I mentioned before, if you're contemplating divorce, looking at a modification, or need help with your parenting plan or time sharing in this uncertain time, please reach out to our office, as we are here for you. We're available by phone at 904-241-0012. We hope you found the information today helpful. Thank you, and see you next time.